got a question I want to ask both of you. So, given the dominant role that certain tech companies play in the public dissemination of information, particularly constituting news and commentary, it would be concerning if they were purposely undermining certain points of view, if they were systematically doing so along partisan political lines, for example. Should viewpoint bias, political viewpoint bias, be the subject of antitrust enforcement? Mr. Delrahim, we'll start with you. Hit the button, if you will.
Sorry. I think, Senator, it's an important question as a matter of public policy, and it's something that I think every American, regardless of point of view, should be concerned about. To the extent it's part of the qualitative analysis under antitrust law, I think that's a very legitimate question. So is a monopolist, somebody that has market power, engaging in any kind of conduct that prevents a competitor who might, have a different viewpoint or allow for different, diverse viewpoints into the marketplace, then I think the conduct that prevents that type of competition will have an impact on the viewpoint that ultimately gets to the consumer. So I think if it's as part of the qualitative analysis of monopolization, in addition to price and output, looking at choice and quality, I think it could be. Outside of that, I think it might be probably a better role. So if it's not within the four corners of traditional antitrust law as we look at it, then it's probably a better role for other public policy tools.
Something similar. The antitrust doesn't seem like it's a tool that's well sculpted for this type of effort. So if somebody just becomes successful and gets a big share because of their success, you could run into the same problems, even though they haven't committed any competitive acts, right? You might also have a problem if the two biggest news organizations merged. You could have a problem, for example. My sense is that this would be something that would be better suited for another set of tools other than the ones that antitrust brings to bear.
Got it. Mr. Delrahim, traditional market definition tools, such as the hypothetical monopolist test, typically rely on pricing information. Pricing information is either elusive or absent altogether in zero-price markets where services are monetized through advertising. So what factors should the Antitrust Division consider in that type of market when conducting this type of analysis?
It's, again, an important element of our analysis. I gave a speech about zero-price products, and the division and the Federal Trade Commission for years, we have looked at markets that are priced zero to a set of customers. However, there's a price tag. As an example, I'll give airplay over the radio for certain music. The consumer is not paying for that. However, advertisers will. Broadcast television is. And so we have to look at the tools of what is, is this consumer's preferences? Are there substitutes for the product? And ultimately, who is paying for that? Somebody is. So let's just pick, as a hypothetical example, a company that provides search services. Even though that search to the ultimate customer may not have actual price, the price of the search to the advertiser may be one area we could examine.
Thank you. That's helpful. And so in that respect, this isn't new. It's not completely unique. It is, there are some models that you can look to. As part of your tech reviews, both of your agencies have been actively soliciting third-party complaints. I realize you have the need to talk to third-party witnesses to investigate and potentially build a case. This makes sense. What I'm always fearful of is I wouldn't ever want to see U.S. antitrust policy start to look like antitrust enforcement in the EU, antitrust policy in the EU, where the primary concern seems to be protecting competitors rather than competition itself. Mr. Delrahim, how will the Department of Justice ensure that U.S. antitrust policy in the tech space remains focused on competition rather than on competitors?
That's a very important part, I think, of our antitrust regime, and we would look at that. We have longstanding Supreme Court precedent that says the antitrust laws are not intended to protect competitors, but competition itself. And that's what we look at, and our enforcement actions should be consistent with that. We also work with our friends abroad, including with the European Commission. And I think more and more we're seeing more convergence. Of course, they have a different regime, both administratively and some of the substantive law under the treaty that they operate in. And so there are some differences, but I think more and more I've been encouraged about the way they look at antitrust and how they apply it.
Mr. Simons, I've heard arguments that data collected by large platforms give those platforms an unlawful, unfair competitive advantage, and that in light of that competitive advantage, we should require these platforms to give their competitors access to see their data. Is it appropriate in your view, Chairman Simons, to treat these platforms as essential facilities? And what, if any, concerns would you have with that kind of approach?
No, I think it's not a good idea at all to treat them as essential facilities or public utilities, because one of the great strengths of our system is that it produces innovation unlike anywhere else in the world, and subjecting an industry to public utility type regulation runs the serious danger of squelching that.
In February, the FTC announced the formation of its technology task force to monitor the tech industry. Is it fair to say that the FTC created the technology task force because there are benefits to having a dedicated staff focusing specifically on those issues?
Yes, absolutely.
Why is that?
Because so we do this with a lot of different industries. So we have a healthcare shop, we have an oil shop, and those industries are such that if you have a background in an industry, it's easier to do a merger evaluation, easier to do an evaluation of anti-competitive conduct because you understand how competition occurs in that industry already.
Did you get that industry? So if you got a dedicated pool of staff who are assigned to look for those factors, know what they're looking for, and they know it when they find it.
Yeah, so they've studied that particular industry. They know how it operates. They know the peculiarities, and some of the industries, like hospitals, for example, have a regulation overlay which is difficult to understand sometimes, and that's particularly true in the context of pharmaceuticals.
So this will make you more effective in doing this.
Yes.
And if that's the case, if you're more effective in having a dedicated team like that, wouldn't you be more effective if you could consolidate those resources rather than having them split into two antitrust enforcement agencies?
Sure.
Do you disagree, Mr. Delrahim?
Hard to disagree with that.